All right, veuillez vous lever. Please be seated. Veuillez vous asseoir.
Thank you. And I can tell Your Honours that we're making good progress. Mr. Lauchi and I will certainly finish before the end of this next session. Just before the break, I was about to embark on a discourse on what we call our second line of defence. Some aspects of this have already been briefly touched upon by Mr. Lauchi, but I make no apologies for repeating these points. They are important and they merit underscoring. In short, we say Mr. Abd Al Rahman was not and could not have been the local Janjaweed leader as alleged in the document containing the charges. The prosecution simply has failed to establish a logical, reasonable or compelling narrative to explain how Mr. Abd Al Rahman could have played the criminal role he is alleged to have played in the counterinsurgency of 2003 and 2004. The thread that runs through the prosecution's charges against him is that he was in a position of great power and authority in Garsila, in Wadi Saleh, and in Mukja. And it was only by wielding this great power and authority that he was able to commit the crimes of which he's accused under the alleged modes of responsibility. And here I refer to Article 25.3b ordering, which requires proof of some kind of superior-subordinate relationship. In other words, that the accused is in fact in a position of authority. And also Article 25.3b inducing, which, whilst it doesn't require formal or proof of a formal relationship of superior-subordinate, it requires proof that the defendant was in a position to exert influence over direct perpetrators. Similarly and logically, so say the prosecution, it was only by virtue of his alleged position of power and authority that Mr. Abd Al Rahman was able to commit a number of the charged crimes through the modes of liability under 25.3a, direct perpetration and co-perpetration, and under aiding and abetting liability under Article 25.3c, and common purpose liability under 25.3d. The prosecution have thrown everything in. But what is clear is that the prosecution do not suggest, they can't suggest, that he's guilty of the crimes with which he's charged under these forms of liability because he was, in fact, merely a foot soldier. No, that the prosecution have made it very clear that their position is that he was a leader and was only able to do what he is alleged to have done because he was a leader. The defense will call evidence to dismantle the prosecution's sand-constructed theory of the defendant's power and authority. And in so doing, we will show just how insubstantial is the edifice of the prosecution's entire case. We will show you that the prosecution simply does not make any sense, that its case does not hold water. Let us recall what the prosecution say Mr. Abd Al Rahman was able to do as a leader of the Janjaweed. He was able to cooperate and coordinate with the highest ranks of the Sudanese government and the Sudanese army at a national level. He was able to cooperate and coordinate with the Sudanese government and armed forces at a local level. He was able to give orders, they say, to government officials and even military personnel of high rank. Let's remind ourselves, who are we talking about? A simple pharmacist from a small town in a rather forgotten part of one of the poorest regions of the country. Okay, well, perhaps a simple pharmacist. Back in the day, maybe he had been a high-ranking and experienced soldier, an expert in military strategy, combat tactics, logistics, field weaponry, military command. That might make sense. In the government's hour of need, faced with a serious and dangerous rebellion in a remote part of the country, far from the centre of power in Khartoum, perhaps this simple pharmacist with an illustrious and accomplished past was plucked out of quiet retirement to save the day. To paraphrase Kitchener, because his country needed him. And yet, not a bit of it. That is not who Ali Muhammad Ali Abd Al Rahman was. It is not who he is. A simple pharmacist? Yes. Retired from the army? Yes. But what did he do in the army? Quite apart from the admitted facts about Mr. Abd Al Rahman's background, the defence will call evidence from witnesses such as D7, who will testify that Mr. Abd Al Rahman was a medical assistant in the Sudanese army. He saved lives, yes, patched up wounded combatants, of course, but he wasn't a combatant himself. You will hear that he was only ever issued with a sidearm, and even then he wouldn't carry it all the time. He wasn't a master strategist or tactician. He wasn't a leader of fighting men in the army. He wasn't even of high rank. He retired as a musaid, a warrant officer, as a medical assistant. Yet the prosecution would have you accept that this is the man that the powers that be in Khartoum chose in 2003 to command the Janjaweed in Garsila, in Wadi Saleh, in Mukjar. It's laughable. The defence will also call evidence from witnesses D1, D2, D3 to speak about the role of the Agid, usually translated as a colonel, in the Taisha tribe, and by extension, the role of the colonel of colonels, the Agid al-Ogada, briefly touched on by Mr. Lauchi a little earlier. We expect defence evidence to demystify the term Agid al-Ogada, bringing the concept back down to earth a little, shedding it of some of the prosecution's more extravagant claims. Defence witnesses will define for your honours, for the first time, what an Agid al-Ogada is in the Taisha context, because that's what's important. We'll do it, seeing as the prosecution didn't take the trouble to do so themselves. Defence witnesses will explain that the role is not some kind of senior Arab military position, but rather much more modest, more local, almost administrative position, as much to do with ceremony as anything else. Essentially a civil role, limited to functions within the tribe, conferring no advantage and no claim to authority beyond the tribe itself. Be that as it may, most fundamentally, and of most relevance to the case involving Mr. Abd Al Rahman, Your chamber will hear from witnesses who are extremely well placed to tell you that Abd Al Rahman simply never was an Agid al-Ogada. He just wasn't. So, having knocked some of the magic dust off the term and role of Agid al-Ogada, we will call evidence that isn't actually disputed between the prosecution and the defense, that Mr. Abd Al Rahman is a member of the Taisha tribe. But more importantly, you'll hear the testimony, again, of well-placed witnesses that the Taisha was a tribe that did not take part in the counter-insurgency. That the Nazir who led the Taisha at the time in question in 2003 and 2004 expressly forbade members of that tribe from picking up arms and engaging in the armed conflict, in the counter-insurgency. And the court will hear evidence from D1, D2, D3, D5 of the serious consequences that would flow from a member of the Taisha who chose to defy such an injunction from the Nazir. From witnesses D16 and D17, the defense will call evidence of the link between the Janjaweed, on the one hand, and the other armed groups that compose the Sudanese armed forces as a whole. Your Honours will hear that members of the Janjaweed were not recruited and did not operate in a chaotic way, but were necessarily part of and subordinated within the PDF and the PPF, the Popular Defence Forces and the Popular Police Forces. Whereas the prosecution, in its document containing the charges and other foundational documents in this case, assert that the Janjaweed were merely allied to the more regular government of Sudan forces, such as the army, the PDF, the PPF, and so on, you will hear evidence from defense witnesses that the Janjaweed was in reality subsumed within, was part and parcel of the PDF and PPF. And so why is this important? Well, it's important because the prosecution have produced no reliable evidence from adequately informed sources that Mr. Abd Al Rahman was ever a member of the PDF or PPF, or even affiliated with a PDF or PPF. Sure, the Central Reserve Forces from 2004, 2005, but not the PDF or the PPF, and that's what's important. So the defense will not merely rely on the absence of any evidence of a relationship, institutional or otherwise, between the defendant and the PDF and PPF. We will call positive evidence that Mr. Abd Al Rahman decidedly and demonstrably did not have any relationship, institutional or otherwise, with either of these forces. Since I've touched on the subject of the CRF, I'll finish with it, Your Honours. The prosecution would have you believe that Mr. Abd Al Rahman, having commanded the Janjaweed in 2003 and 2004 on a number of brutal yet successful campaigns, glorious campaigns, I suspect the government of Sudan would describe them, in Sindhu, in Kudum, in Bindisi, Mukjar, Delej, all the locations with which the chamber is very familiar. The prosecution would have you believe that this powerful, this mighty Agid al-Ogada then dismounts from his horse, removes his turban, lays down his machine gun, and wanders off to join the reserves as a lowly recruit. to graduate in summer 2005 as what has been translated in French as a débutant, essentially a private. We say that doesn't make any logical sense whatsoever. It does not survive contact with a proper forensic analysis of the facts. And in the fullness of time, we will make our submissions about the extent to which this defense evidence contributes to undermining the foundations of the entire prosecution case against Mr. Ali Muhammad Ali Abd Al Rahman. I end now by turning back to Mr. Lauchi, who will complete the defence's opening by speaking about the third line of defense, but not before thanking Your Honours for your attention. Thank you.
Yes, thank you, Mr. Edwards. Yes, Mr. Lauchi.
Je vous remercie.
Mr. Lauchi, thank you very much, Your Honour. I would like to conclude my arguments with a presentation of our third line of defense, and this is about the lack of proof of the mental element knowledge that is required under Article 30, subsection 3, and Article 32, subsection 2 of the statute of the court. Pursuant to Article 66.2, the onus to prove the charged crimes falls to the office of the prosecutor. Amongst these various elements, we find the mental element of knowledge, which is required under Article 30, subsection 3 of the statute, and this is common to all the crimes charged. It requires awareness that a circumstance exists or a consequence will occur in the ordinary course of events. Under Article 32, paragraph 2 of the statute, a mistake of law may be a ground for excluding criminal responsibility if it negates the mental element required by such crime. I now turn to another document, the Elements of Crimes, and the general introduction, namely paragraph 3. Quote, the existence of intent and knowledge can be inferred from relevant facts and circumstances. Necessarily, it emerges from this provision that review of the relevant facts and circumstances of a case can lead to the opposite conclusion, namely that there is no intent, no knowledge. The pretrial brief written by the OTP includes 551 paragraphs, and we find that the OTP devotes only 4 paragraphs to demonstrating the mental element, namely paragraphs 84 to 87. The only knowledge that the OTP mentions in their submissions in these 4 paragraphs is knowledge of the fact that the actions allegedly taken by Mr. Abd Al Rahman were part of a widespread and systematic attack upon the civilian population of Wadi Saleh and Mukjar. Knowledge of the fact that the actions by an accused were part of a widespread and systematic attack upon the civil population is different to the mental element specific to only crimes against humanity set out, or rather defined in Article 7 of the statute. This is different to the mental element of knowledge defined in Article 30, paragraph 3 of the statute, which is common to all crimes within the jurisdiction of the course. This final knowledge under Article 30, paragraph 3 of the statute is not pleaded anywhere in the OTP's pretrial brief. At no time did the OTP bother themselves to report evidence in this regard. The defense intends to adduce evidence showing that the particular circumstances that prevailed in Sudan in 2003-2004 show that Mr. Abd Al Rahman retired from the army at the very latest by the mid-1990s. This man, who was a pharmacist in Garcila, could not have had knowledge of the criminal nature of the actions, or the crimes rather, that he has been charged with. The defense shall actually demonstrate that, on the contrary, on the basis of information and knowledge that Mr. Abd Al Rahman could have reasonably had in 2003 and 2004, he could only be persuaded that not carrying out orders to carry out these actions would be a serious crime under Sudanese law that would require the death sentence. Thus, the defense shall submit that Mr. Abd Al Rahman could not have awareness that the circumstance of the reprehensible nature of the actions that he has been charged with existed. The mental element that is required under Article 30, paragraph 3 of the statute is thus absent when it comes to his specific knowledge of the double circumstance, first of all, of the character nature of the actions, and secondly, the lack or absence, rather, of positive obligation once the orders had been issued by the authorities. This second aspect will be considered from the vantage point of an error of law which does away with the mental element of knowledge as defined in Article 32, paragraph 2 of the statute. I shall pause for a moment to specify immediately that this third line of defense does not represent any kind of admission of Mr. Abd Al Rahman participating in the charged crimes. That he might have committed them, which is challenged or not, that he may have been a militia leader, which is challenged, or a simple pharmacist. Mr. Abd Al Rahman could not have had the knowledge, the relevant knowledge required under Articles 30, paragraph 3 and Article 32, paragraph 2 of the statute in 2003-2004. The third line of defense does not constitute a ground for excluding criminal responsibility under Article 31 of the statute, nor is it an excuse under Article 33 of the statute. I reiterate, the third line of defense is founded only on Articles 30, paragraph 3, and Article 32, paragraph 2 of the statute, and should be considered by the Chamber as during their deliberations. What are the relevant circumstances that should be considered? The relevant circumstances that the defense would ask the Chamber to consider include the following elements. First element. In 2003-2004, Sudanese law contained no definition of crimes coming under the jurisdiction of the court. Witness D16 shall confirm that the first time the concept was introduced into Sudanese domestic legislation was in 2007 when the Armed Forces Act was passed. These behaviors were not the topic of any specific incrimination at the time of the events in Sudanese domestic law. Secondly, the international definitions of the crimes, definitions that stem from international conventions, international customary law, or United Nations Security Council resolutions, were not applicable in Sudanese domestic law. Witnesses D16 and D23 shall provide a comprehensive and detailed presentation showing that there was no direct applicability in Sudanese law of the sources of international law, which had not been implemented by way of domestic legislation. Third element. In the absence of specific incrimination of violations of international humanitarian law in Sudanese law applicable in 2003-2004, the only incriminations that such behaviors could have been followed with were infractions of common law set out in the criminal code. But the lack of specificity is such that the repression of crimes under military law and the jurisdiction of military courts clashed with the excuse of military necessity as applied and interpreted by Sudanese courts. Witness D16 shall give evidence about how Sudanese courts would interpret and apply the doctrine of military necessity and impunity that would result for those responsible for violations of international humanitarian law at that time. Fourth, Sudanese military law, which applied to the militia that Mr. Abd Al Rahman has been accused of being associated with, set out an absolute requirement to obey orders issued, or otherwise people would face the death penalty, with no distinction between the lawfulness of the order issued. This distinction between a lawful order and illegal orders appeared in Sudanese law only later, in 2007, when the Armed Forces Act was passed. This distinction did not exist in 2003-2004. The only criteria of a lawful order given at the time of the events was In the absence of such a distinction, the position of authority of the perpetrator of the order, the person issuing the order, and these orders had to be obeyed. Otherwise, the person would face the death penalty. Fifth, only higher ranking officers, commissioned officers, those who had a command, received training in international humanitarian law within the armed forces at that time, at the time of the events. This situation changed only later. Once again, in 2007, when the Armed Forces Act came into effect, which provided that the training would be given to all military staff. Once again, witness D16 will give direct, detailed evidence about the expanded training in international humanitarian law within the Sudanese armed forces. The last two circumstances that I have mentioned, namely the lack of a definition of crimes coming under the jurisdiction of the court in Sudanese law at the time of the events, and the non-applicability, the direct non-applicability of international sources, were also identified in the brief of October 2, 2023, relating to the respect of the principle of legality nullum crimen sine lege. The lack of incrimination of the acts charged in applicable law in Sudan at the time of the events is such that the criteria set out by the appeals chamber in their ruling 088 of 1 November 2021 for the verification of the respect of the principle of legality nullum crimen sine lege has not been satisfied. Thus, the appeals chamber prescribed in paragraph 91 of their decision 088, your chamber will have to determine whether the criteria has been satisfied or not in advance, and before deliberating on the substance of the case, and will have to declare itself to be not having jurisdiction in order to come to a decision regarding the substance. Independent of the satisfaction or not of the criteria set by the appeals chamber, there are 5 circumstances previously mentioned that the mental element of knowledge required under Article 30, paragraph 3 of the statute has not been established in this case. The parties agree that Mr. Abd Al Rahman did leave the army for once and for all between sometime in the 1990s, between the beginning of the decade and the middle of the decade. This is fact number 10, agreed fact in the joint submission by the OTP and the defense, ICC 0205012504, Annex A. There is no evidence that Mr. Abd Al Rahman ever reached any rank higher than warrant officer Musaid. Mr. Abd Al Rahman was not made aware of or was not given any basic training about the principles of international humanitarian law. For example, the principle of distinguishing between combatants and non-combatants, protection of civilians and people deprived of liberty. The only knowledge that he may have gleaned during his military career on these issues was the absolute lawfulness of orders given by military superiors and the requirement to obey these orders or face the death penalty, and the justification of behaviors during operations in accordance with orders received because of military necessity. The only diploma that we know about that Mr. Abd Al Rahman earned was an authorization to work as a medical assistant. He obtained this diploma in 1984 when he was serving within the medical services of the Sudanese Armed Forces. The OTP has never claimed that Mr. Abd Al Rahman had reached any kind of level of education, no higher levels of education, no legal training during his life. The only deduction that can be reasonably made from the relevant circumstances in this case is that Mr. Abd Al Rahman could not have known that the crimes with which he has been charged were reprehensible, and the only knowledge that he could have reasonably had would have led him to the opposite conclusion, namely that resisting an order or an instruction given by a superior would be a military crime, an extremely serious military crime, and such a crime would be punished with the death penalty under domestic law. The mental element of knowledge of the reprehensible nature of the act and the lack of obligation to obey the order to carry them out under Article 30, Paragraph 3 of the statute is thus absent. If the acts had been committed, which is challenged, they would have been committed on the basis of an error of law, as set out in Article 32, Paragraph 2 of the statute, which would negate the mental element of knowledge and the knowledge that obeying the order was a legal requirement, and if the order was not complied with, the person would face death. Insofar as the mental element of knowledge is common to all the crimes charged, and the lack of an error of law applies also to all the crimes, the lack of knowledge and the existence of this mistake shall naturally lead to the complete and utter acquittal of Mr. Abd Al Rahman of all the charges standing in his name. This brings me to the end of my presentation regarding the third line of defense. I shall now turn to our conclusions.
Voilà ainsi en résumé au cours de ces 3 sessions.
During these 3 sessions, we have summarized the evidence that the defense intends to adduce during the trial. This evidence is not completely available as we begin our presentation before your chamber, but that is because of matters beyond our control. It is your chamber's task to make a choice between a fast-track trial and a fair trial conducted with respect of the fundamental rights of Mr. Abd Al Rahman, particularly his right to have sufficient time and facilities to present his evidence and his right to call exonerating witnesses. Exercising these final rights, we have been compromised in our view. It is up to your chamber to make a decision namely to offset the prejudice that has already been caused to Mr. Abd Al Rahman by granting the defense more time. The opportunity to make such a decision will be provided to you when the first application to postpone presentation of the evidence of the defense, once that application is filed, and this should be rather soon. We are attentive to the interest that your chambers shall devote to the rights of the defense, and we will be able to draw all necessary conclusions. This brings our presentation to an end, and I thank you all for your attention.
Mr. Lacci, as I said yesterday, you made a number of complaints, and you now say that you're going to be filing another application to adjourn at some stage. I'm afraid you're going, if that's what you want to do, you've got to file it sooner rather than later, because the court will be making arrangements to sit.
Madame la Présidente,
Your Honor, the announcement of such an application is based naturally on decisions by your chamber to authorize the defense to continue disclosure of its evidence on a rolling basis. And this is something that lies at the very heart of your decision to stick with the start date for presentation of the case in October, this block in October. We continue our investigations, and as of next Friday, I will be traveling elsewhere to continue investigations. There are a number of witnesses, as my colleague has said, and I shall reiterate this point. There are a number of witnesses for whom we have not been able to collect written statements. We are doing all we can to make this happen. Once we have exhausted the number of witnesses available at present, and this could perhaps take us as far as the first week of December, but no further than that, and then we will run out of witnesses to call. Thus, we will have to go off again and conduct further investigations and then add to the list of witnesses. That will mean a suspension, or you may rule that the presentation of the evidence of the defense has concluded, and that is when the decision shall be made. At present, I am not in a position to predict exactly when that will end. We have a meeting with the victims and witnesses section to discuss the matter this afternoon. The best I can say is that once the meeting is over, I shall forward the schedule of witnesses who are currently available, and that will naturally determine the date at which the defense will find itself without additional evidence to bring before the court, unless the defense continues its investigations at that time.
Right. Well, Mr. Lacci, we feel, given you exceptional leeway already because of the circumstances of what is taking place in Sudan, to disclose your evidence on a rolling basis, which could be said to put you at a far greater advantage than the prosecution had during the course of its case. But what I'm concerned about is that if you come to the conclusion you're going to run out of witnesses by the first week in December, then you should let the court know as soon as possible. We have in fact been discussing the date for a restart after the Christmas break, and it's likely that we will give you at least until mid-January, something like the 15th. So, but it is important that you give advance notice with enough information for us to make an informed decision if you actually are asking for any kind of adjournment.
C'est parfaitement noté, Madame la Présidente.
Entirely noted, Your Honor, and as I was saying, I would suggest that we provide that information once we've had that meeting late afternoon today with the VWS. So we shall be writing to the Chamber and the parties over the course of the weekend, or at the latest by Monday.
Yes, all right. Yes, thank you very much. Is there anything further that anybody else wants to raise before we adjourn? No, well then we'll adjourn now until Monday at 9:30. When you say it'll be witness D16, is that right, Mr. Lacci? Witness D16 Monday morning.
Oui, c'est cela. Et d'ailleurs,
Answer, yes, indeed.
suggéré
As my colleagues were suggesting, I'll take this opportunity to say that during the hearing, we received information, positive information, and thus we are in a position to say that
concernant
inaudible.
Positive information about the matter we discussed earlier.
précisément.
All right, okay. Well, I'm...
Yes, yes, indeed, exactly.
All right, thank you very much. Yes. Monday at 9:30.
All rise, veuillez vous lever.